is no notice in respect of the dargah.
Yes.
It is only in respect of the structure inside the dargah. They have demolished every dargah also.
Yes.
Your Lordship, I want your Lordship to see everyone. હાજી બંગલોડિયા શાહનું મકાન દરગાહની દિવાલને અડીને દરગાહની બહારના ભાગના આપને દ્વારા પાતળું ઓઢીનું બાંધકામ કરવામાં આવ્યું છે. The Lordship can see everyone. This is up to page 441. સાર સલાશા મકબરા ના બહારના ભાગ. There is no notice in respect of dargah or maqbara.
Yes.
This notice is only confined to the structures outside the dargahs and maqbaras.
Yes. Yes.
And second thing, there on what basis these are illegal, nothing is mentioned. Now this is one part. The Lordship may then see page 443.
Page number?
443. The first paragraph is that they have agreed to become punchers. Now this is dated 5/9/2024, same date, the date of the notice. The two punchers are Bamaniya Bhavinbhai D, Gavadia Jayeshwara. પ્રભાસ પાટણ ગામે GIDC ની સામેના ભાગે પીડિયાથી પ્રભાસ પાટણ તરફ જતા રસ્તે માર્ગની જમણી બાજુએ આવેલ માયાપુરી મકાન દરગાહ નામની દરગાહના બહારના ભાગે બાંધકામ કરી બિનઅધિકૃત દબાણ કરવામાં આવેલ છે. જે દબાણ તાત્કાલિક ખુલ્લું કરવા માટે જમીન મહેસૂલ અધિનિયમની 1879 ના કલમ 202 હેઠળ માયાપુરી મકાન દરગાહના વહીવટકર્તાને નોટિસ બજાવવાની સિટી તલાટી પ્રભાસ પાટણ તથા સર્કલ ઓફિસર વારંવાર આવતા. My Lordship may read it again, my Lord. I am just saying. નોટિસ બજાવણી અર્થે સિટી તલાટી પ્રભાસ પાટણ તથા સર્કલ ઓફિસરથી વારંવાર શહેર આવતા સદ્રુ નોટિસ સ્વીકારવાની વેરાવળ શહેર આવતા સદ્રુ નોટિસ સ્વીકારવાની માયાપુરી મકાન આછીપુરી દરગાહ હતા વહીવટ કરતા મનાઈ કરેલ છે, જેથી સદરુ નોટિસ નરી આંખે દેખાય તેમજ તમામ જોઈ શકે તે રીતે મિલકત સ્થળે લગાવવામાં આવેલ છે. ઉપરોક્ત નોટિસ અમારા પંચો રૂબરૂ મિલકતો સ્થળે લગાવવામાં આવેલ છે, જેની ખાતરી બદલ અમો પંચો અમારા પૂરા હોશમાં વિના દબાણ કોઈ પણ જાતની શેર શરમ રાખ્યા વિના વાંચી વંચાવી સમજૂતી વિચારી નીચે અમારી સહીઓ કરેલ છે. Well, there is no photograph produced of this being stuck on 5/9. There is absolutely no evidence except the witnesses, and the same witness is there in all the 5 panchkyas, 7 panchkyas, 9 panchkyas.
Yes.
Same person. There should be some evidence that they have stuck it.
Yes.
Well, 5/9 is the purported notice, no time period given, how they have affixed it, No photograph produced. Well, this is one background. Now, my lord, your lordship may go to the 27/9/2011 and section 211. Your lordship may have a look at paragraph 16 and 17 of the full bench judgment of Gujarat High Court.
Yes.
Para 15, last line of para 15. In view taken in the aforesaid two decisions that notice under section 202 of the code is in itself a decision or order of eviction is not correct. Para 15, last line.
Para 15.
Para
Yes,
15,
lines in para.
last line of para 15.
1991 2G.
I am referring to the 4-line para only.
1976.
Am I correct? Lord, is it justice full bench judgment?
So, yes, my lord.
So that judgment only.
1976.
Yes, my lord. I'm referring to the same judgment.
This is a very simple.
My lordship may go to paragraph 15. May I read from para 15 so that the whole para. D.A. Desai in special say implicitly relied upon a decision of Chimanlal's case, and a division bench in latest patent appeal agreed with the view of D.A. Desai. In our opinion, speaking with great respect, the view taken in the aforesaid two decisions that notice under 202 is in itself a decision or order of eviction is not correct. Now I am reading further. Therefore, on the question reframed by us, it should be, we hold that the notice under eviction under 202 of the code does not amount to a decision or order of eviction. But the said decision or order has to be taken under some substantive provision conferring on the collector power to evict persons wrongfully in possession of the land contained elsewhere in the code or in any other act for the time being in force. In view of this, answer to the first part of the question, there is no question of giving opportunity to be heard to the person against whom decision of eviction has been taken before issuing notice under 202 of the code. However, such an opportunity should be given while reaching the decision of making the order of eviction under a substantive provision of the code or any other act for the time being in force, conferring on the collector power to evict the person wrongfully in possession of the land. There can be no dispute about the application of principles of natural justice and giving of opportunity to the person concerned to be heard before reaching a decision or making an order of eviction, which is to be executed under section 202 of the code. The position at law as regards the applications of principles of natural justice is quite well settled. Only a couple of decisions of the Supreme Court may be pointed out in the connection. In Government of Mysore versus J.V. Bhatt, the Supreme Court pointed out that if there is a power to decide and determine to the prejudice of a person, duty to act judicially is implicit in the exercise of such power. It is also said that the former distinction between administrative power and a quasi-judicial power is being gradually obliterated. On the earlier occasion in Dawood Ahmad, a larger bench of the Supreme Court pointed out that the principles of natural justice have been made applicable to administrative inquiries or quasi-judicial inquiries, where they affect the right of the person. We may make it clear, however, that the notice to be given under 202 should be of a reasonable time. The person on whom such notice is served may appear within that time and make some representation to the collector requesting him to grant some time to vacate, which the latter may consider. It is also clear in the later part of 202 relating to removal of resistance or obstruction does not contemplate a summary inquiry, and therefore principles of natural justice would be applicable in that inquiry. However, in view of Justice D.A. Desai, in special CA, that the notice under 202 itself amounts to a decision or order of eviction, and that the person in wrongful possession need not be heard at that stage, and he will be entitled to be heard because of the later part of 202, which contemplates a summary inquiries in is with respect not correct in view of the reasons given by us. The later part of 202 comes into operation when there is a resistance or obstruction in removal of a person from the possession of the land. Speaking with respect again, it would not be correct to hold that a person sought to be evicted from the land under 202 by notice in order to be entitled to be heard should offer resistance or obstruction, and that the right to be heard would flow from the resistance or obstruction to the execution of the notice of eviction. In fact, in the view that we have taken on the first part of the question reframed, the aforesaid view of Justice D.A. Desai does not survive. Our answers to the questions reframed are as under. A notice under 202 does not itself account to a decision or order of eviction of a person wrongfully in possession of the land, but is only a mode of enforcement of such decision or order recorded under a substantive provision of the code. There has to be some order that we have to be evicted. We may be unauthorized, but there has to be an order where we are required to be heard, that we have to be evicted, of the code or any other act for the time being in force conferring the power on the collector to evict such person. In view of the above conclusion, the question of application of principal justice at the issuance of notice does not arise. It is made clear, however, that the principle of natural justice would be applicable at the stage of recording the decision or order to evict in case of exercise of powers of under 61 or 79A of the code, which are some of the substantive provisions in the code conferring such power on the collector. The summary inquiry contemplated by the later part of 202 is not meant for reaching or recording a decision or order of eviction. It applies to the contingency of resistance or obstruction, taking possession of the land in the course of enforcement of a decision or order to evict made under the provisions of the code, under section 61 or 79A or any other act, for the time being in force, empowering the collector to evict a person wrongfully in possession of the land. Therefore, there has to be some order under 79A. Your Lordship would have a look at section 79A.
Yes.
Any person in unauthorized occupation or wrongful possession of any land, to use or occupation of which by any reason or any of the provisions of the Act he is not entitled to or ceased to be entitled to, or which is not transferable. I'm not reading the second portion. First portion is enough because that deals with 73AA. May be summarily evicted by the collector. Under this, there has to be an order. Without that order, 205 notice can't be issued. Look, there is nothing on record today from even their reply that there was an order under 79A. Look, the court has also referred to section 61, so I'm referring to even section 61. Lord, I was aware of 79A, but let me see 61. Any person who shall be unauthorizedly enter upon or occupation of any land set apart for a special purpose or unoccupied land which has not been alienated, and any person who uses or occupies any such land to the use or occupation of which by reason of any of the provision of he is not entitled or ceased to be entitled, shall, if the land which he is unauthorizedly occupies forms part, all that, then the collector can decide upon it. Last paragraph. The person unauthorizedly occupying of such land may be summarily evicted by the collector. So the first has to be a decision whether I am in unauthorized occupation or not. I may be filing a suit. I may not have got an injunction in that suit.
Yes.
But before they take action, there has to be notice under 179A. There has to be a hearing. And thereafter, there has to be an order which is followed by a 202 eviction order. There is nothing on record to show that any such action has been taken by them. Now, my lord, one thing. Second thing, your lordship would have a look at the notice which is given under on 12th September.
Page number.
Just one minute. Yeah, page plus one.
12 September.
Hmm.
I think 12 per precise.
No, just 1 minute.
345 purchase.
Huh?
345.
Third page 345. I'm sorry.
Yes.
Below paragraph 1, after 6 lines.
Yes.
Or Milord, I'll read from the beginning. આ નોટિસથી આપને સૂચિત કરવામાં આવે છે કે પ્રભાસ પાટણ સિટી સર્વે બ્લોક જી સિટી સર્વે ક્ષેત્રફળ 1136 તારીખ 23/2/47 થી સાર્વજનિક સરકાર ધરાવેલ છે. આકેલ કાર્ડમાં શ્રી સરકારનું નામ દાખલ થયેલ છે. સિટી સર્વે સુપ્રિન્ટેન્ડન્ટ શ્રીના અધિક મામલતદાર પાટણ દ્વારા રેકોર્ડ ખરાઈ કરતા ગરબેણી ઓફિસર 23/2/47 ના ઠરાવ વિગતે પાટણ બ્લોક નંબર જી સર્વે નંબર 6 વાળી ભેણી માયપુરી મકાનની છે. આ જગ્યાને પાટણને ઘાંચી લોકો માને છે, પણ જગ્યા સાર્વજનિક છે. આ જગ્યા માલિકી હક નથી, તેમ છતાં આંક 4 ઉપર હસન અલી ખત્રી ખાતરી આપે છે. સબબ આ ભેણી સાર્વજનિક સરકાર માલિકીની ઠરાવેલ છે. સદરુ મિલકત ઉક્ત હકીકતે મુજબ સાર્વજનિક સરકારી ઠરાવેલ હોવા છતાં પણ હાલ માયપુરી મકાન ઘાંચી હસન અલી શ્રી સરકાર એમ નોંધાયેલ હોય, જેથી ધારણકર્તા તરીકે માયપુરી મકાન ઘાંચી હસન અલીનું નામ દૂર કરવા સિટી સર્વે સુપ્રિન્ટેન્ડન્ટ અનેક મામલતદાર શ્રી પાટણ તથા નાયબ કલેક્ટર શ્રી વેરાવળ એ હકારાત્મક દરખાસ્ત રજૂ કરેલ છે. So it's a proposal that his name should be removed from the records. Otherwise, his name is appearing.
Yes.
So if his name is appearing, one more factor, how can action under 79A also lie before his name is removed? How can you put the cart before the horse?
Yes.
My name may be wrongfully there, but today I am an occupant is shown in the records. Now, if that name is there, that has to be first action has to be taken under 211 to remove my name. After that, a notice under 79N has to be issued. And after that, 202 has to be taken. You can't start with 202 and demolish everything. And certainly not a single notice is for the dargah and the Kabristan. It is only for some huts that no notice is given.
Yes.
And in spite of that, everything is demolished completely. It's not only the hutments which have been removed. All the dargah and everything have been demolished. Even ancient, I highlighted there, some of them are ancient monuments. They have also been demolished. Your Lordship, then your Lordship may see. 4 કલાકે 19/9/2024 ના રોજ. Now 19/9/2024 adjournment is granted to 27/9.
Yes.
Lord, I highlighted that. Oh Lord, on 19/9 it is adjourned to 27/9. On 27/9 we have not given any reply. We have only given an application for adjournment and certain documents.
Yes.
Now, my lord, the decision is taken on 27/9.
Yes.
Now, if your lordship would see, the 27/9 decision has to precede the notice under 202. It can never happen that it has, I am a legal occupant as per the records of the revenue, yet notice can be given under 202. I have to be first an unauthorized occupant.
Yes.
So this order has to precede it. Yet 202 notice is given
Yes.
on 5/9 and more than how many 300 people, police was there, and on 28/9 this has been removed. Now, my lord, with this background, And in light of the Supreme Court order and in light of the observations made by the Supreme Court subsequently on the next day in a writ petition, in a petition filed for contempt, Lord, my humble submission is that a status quo order is required to be granted.
એક issue નથી. Punitive damages નું punitive arrest નું issue નથી.
Lord, the contempt petition which is filed before the Supreme Court, where the court has, it is nothing to do with the criminals whose property. It was only hutments which were sought to be removed.
So, what?
Only hutments. Petition I have got.
Yes,
Contempt petition. It is hutments which were sought to be removed.
not even.
No, not the criminal. Because the order is, Lordship can't truncate the order. Nobody can truncate an order which is wide. The Supreme Court can itself clarify it. It has clarified to what extent it wanted to clarify. So otherwise it's a blanket order. I can,
એ નથી accept થોડા છે.
Lord, we have just received a copy, Lord. I can hand over the copy to your Lordship on an iPad.
What?
Of Supreme Court, sir. Supreme Court contempt petition. Where the contempt is alleged of and the prayer. We have not been able, the order is yet
What
not updated.
happened to that contempt proceedings?
I'm sorry.
Order is passed, Lord.
Yesterday, order is passed. Yesterday.
I gave the order yesterday. I am trying to.
The-
Order?
Petition of.
Sorry. Petition. Para 4. Wait. Para 4. Facts.
Lord, I am just reading out the facts.
Yes,
The petitioners, along with others, have been residing in the said village of Katholi Pathar, revenue village under Sonpur Mauza in the district of Kamrup Metro for last many years. Petitioners have been residing in the said land by virtue of a deed of power of attorney which have been executed in their name by original Pattadas. The petitioners are not the owners of the said land and they do not have any ownership right. However, they are enjoying the occupation and residing over the said lands by virtue of power. That the petitioners beg to submit, contrary to the allegations, assertions of the district administrative authorities, the petitioners are illegal occupiers and encroachers of the land of the tribal or the protected class. They have been residing in the lands wherein they have been allowed to live by actual patadas. In many of the cases, the actual patadas have been from people belonging to the protected class who allowed the petitioners to say. However, the said lands were not sold to the petitioners. Neither the petitioners have asserted any ownership or possessory right. It is only that the authority to reside and manage the said lands has been vested upon the petitioners by the original patadas. In case of some of the petitioners, they are legal heirs of the next kins of the original patadas. However, the petitioner in no way encroaches or occupiers of the said land, therefore they have not committed any violation of the provisions of the Assam Land and Revenue Regulations, as because they have not changed the name, nature or character. And in this matter,
Prayer.
the prayer was initiate contempt proceeding against the alleged contemners, respondents herein for committing gross, deliberate, willful of the Honorable Court for deliberate and willful violation of the order dated 17 September. And below the respondent in the petition IAS officer, principal secretary, government of Assam, and district commissioner, government of Assam. So that was all dealing with UP.
Mm.
And this order has been passed, Lord. I gave the order yesterday. We have not yet received the
It's not uploaded.
uploaded as well. Now, Lord, in this light, Lord, under 202, no time period given to demolish. 202 is only confined to the huts outside. They could not have demolished the dargah, and the action is taken. That's all.
Yes. Yes, Mr.
Page 416. The order of the Honorable Supreme
Yes.
at page 419, my lords.
Yes.
But before I read this order of 17-9, I had given to my lords the 2nd September order. Would my lords please have it? I have another copy also.
Yes.
Am I with me? If I may read, lords, from paragraph 2. The present batch of petitions raises a grievance that the properties of persons who are accused in some crime are being demolished. The position is disputed by the state of Uttar Pradesh and an affidavit has been filed that the immovable properties can be demolished only in accordance with the procedure prescribed by law. An affidavit has been filed on behalf of the state of Uttar Pradesh by Special Secretary Home Department, Government of Uttar Pradesh. We appreciate the stand taken by the state of Uttar Pradesh in the affidavit filed by it. We propose to lay down certain guidelines on a pan-India basis so that the concerns with regard to issues raised are taken care of. My lords, issues would be para 2. And in that background, para 6. We find it appropriate that learned counsel for the parties may give their suggestions. In this background, my lords may now see 419 for a moment.
Yes.
As requested by Mr. So-and-so, learned so-and-so appearing for the respondents, list these matters on 1/10/2024 as first item. Till the next date of hearing, we direct that there shall be no demolition anywhere across the country without seeking leave of this court. We further clarify that our order would not be applicable if there is an unauthorized structure in any public place, such as road, street, footpath, abutting railway line or any river body or water bodies, as also cases where there is an order for demolition made by the court of law. My lords, 2 submissions. While having 419 at hand, if I may pray, my lords have 508, my reply. I also have the revenue map, but 508 makes it abundantly clear in my submission.
50.
508, my lords, of my reply. This is the notification dated 3rd November 1951 by the Saurashtra government. If I may read from the bottom of the page. In supersession of this department, GR number so-and-so dated 27th July 1951. The government of Saurashtra is pleased to grant to the Somnath Trust on lease of 999 years on payment of annual rent of rupees 40 for additional lands as described below. I pray my lords have serial number 4. Government wasteland and strip of land west of Patan town, largely consisting of sand dunes, lying on the south of Veraval Patan road, up to seashore excluding privately owned trees and houses. My lords, this is a waterfront land which abuts the water body. So
Yes.
in that background, it is forming part of the exception carved out in para 3 of the Honorable Apex Court's order at page 419. Number 2.
Land won't have a survey number. Lord, my learned friend is saying this is a waterfront land. This
I'm
is a
taking-
survey number land.
You can read.
There is a road in between.
There is no road in between. I'll take my lords to the map also. Abutting railway line and or river body or water bodies. The second submission. This would not apply to any public place. If my lords were to have page 112, the property card that the petitioners have themselves produced on record. Each of those property cards clearly reflects, if I may pray, my lords have just below Shri Sarkar, number so-and-so, Tariq 23/2/47 thi, Sarvajanik Sarkari Haravel Che. Am I with the Honorable Court? My lords, if my lords are at page 112,
Yes.
if my lords are in the column that starts with Dharan Karnar, Shri Sarkar, the last sentence, my lords. So-and-so, Tariq so-and-so thi, Sarvajanik Sarkari Haravel Che. So these are public lands. They are government lands, but they are public lands. The third submission, in this background, if the earlier order of the Supreme Court is seen, there is a clear understanding that this applies to cases that are subject matter of these proceedings. And although Mr. Thakur in the first half said that they have not approached the Apex Court, what is reported in the online media is that one Samast Patni Muslim Samaj has approached the Honorable Apex Court today morning for this very cause of action, seeking initiation of some form of contempt. This is the position as I understand. It is reported on the portal that Mr. Thakur relies on. In that background, I may now take my lords chronologically through the sequence. My lords, the petitioner,
Mr. Bell,
my lords,
in this very connection, the matter has gone up to the.
that is what is reported in live law. That for this very
We have
issue,
not done it. We can say
obviously, in all these matters, only the Oliadin committee is the same. Every other signatory is different. Every time 5 new persons are signatories before various honorable courts. Obviously, they would not have done it, but I refuse to believe that they were not aware. My lords may have the property card at page 112, which is the basis of the petitioner's case.
What is the nature of the proceedings before the apex court? Which have been
My lords,
conducted?
because it is not reflected on the website of the Honorable Apex Court as of this moment, I would not be in a position to say that. But the live law reporting, which culls out even the names of the drafters of the petition, says that this is in connection with the actions taken by the state government at Gir Somnath Veraval. And it is quote unquote, respondents herein have carried out early morning illegal demolition of century-old religious places of worship without issuing notice for such demolition, without granting opportunity. The petitioner claims that the authorities in Gujarat violated the order dated 17 September by carrying out demolition. The petitioner seeks initiation of contempt proceedings, impledes the state's principal secretary, a collector and district magistrate, SP Gir Somnath as party. The matter is listed before the bench of Honorable Justice Shri so-and-so today. The petition has been filed through advocate on record Shri so-and-so and drafted by advocate so-and-so and so-and-so. This is reported at around 10:09 a.m. So that is submission number 1. If the Honorable Court were to see the property card at page 112, admittedly, these are government lands.
Yes.
And in this context, your ladyship may please have page 123, which is the deed of settlement of the Shri Somnath Trust, dated 21/1/1950, my lords.
Yes.
In sequence of chronology, this would be the first document, which then, I'm sorry, page 123, my lords, which then would be followed by the document at page 508, the Revenue Department notification of the Saurashtra government, which my lords just saw,
Yes.
which is dated 3rd November 1951 at page 508.
Yes.
Now, my lords, in the interregnum, what is significant, I'm sorry, page 508.
Yes.
In the interregnum, what is significant is a possession receipt, which is at page 151, produced by the petitioner itself, which is dated 1/7/1951, and a sketch that is produced therewith. If I am with my lords at page 151, my lords, I will try and, because the copy provided to me is extremely bleak. Saurashtra Sarkarna revenue khatana so-and-so number so-and-so Shri Somnath Trust ne Veraval Patan વચ્ચે ચૌધરીના બંગલાથી પાટણ શહેરના દરવાજા સુધી દક્ષિણ તરફના સરકારી પડતર જમીનનો ભાગ આ સાથે સ્કેચમાં દર્શાવેલ so-and-so તથા નંબર so-and-so માં સોંપવાના થતા હોય, આજરોજ સદરહુ so-and-so સોંપવામાં આવેલ છે. And if my lords were to turn the page and have 152, a sketch is produced by the petitioners.
Yes.
If my lords may permit me to read the lines below the sketch, I may start from the first of those 3 long lines.
Yes.
The first line, as I read it, reads, my lords, આ રંગથી બતાવેલ સર્વે નંબર 1853 છે, તેમાં કુલ 182 એકર 23 ગુઠા છે. The line below that, my lords, આ રંગથી બતાવેલ સર્વે નંબર 1853 નો ભાગ શ્રી સોમનાથ ટ્રસ્ટ ને સોંપવાનો છે, તે 122 એકર 20 ગુઠા અને તેમાં બતાવેલ નિશાન એ વાળો રિઝર્વ ભાગ પણ આવી જાય છે. And then below that, my lords, સોંપવામાં આવેલ છે, કુલ સોંપવામાં આવેલ છે, the survey numbers.
Yes.
This, my lords, is 1st July 1951, followed by the resolution at page 508, followed by the lease agreement at page 153, the next page, between the government of Saurashtra and the Shri Somnath Trust.
Yes.
Now, my lords, at this juncture, there is only one document that I may be permitted to show. The party before my lords in the present petition is one Auliya-e-Din committee.
Yes.
The PTR of the Auliya-e-Din committee is at page 174.
Yes.
If my lords were to oblige me by having 175 and 176, the roster of properties in the PTR says Nathi at 175, and once again Nathi at 176.
Yes.
In that background, matter was carried before our Honorable High Court in the year 1983 at page, I'm sorry,
Yes.
at page 512, the order of our Honorable High Court in SCA 4232 of 1983. At page 512 of my reply. If I may read the quoted portion, which is the order. Mr. So-and-so appearing for the state government states that there is a dispute about the ownership of the land in question. The government will initiate inquiry under section 37(2) of the Land Revenue Code within 6 weeks from today. On that statement, the petition is treated as infructuous and rejected as such. Boundaries, if any, existing at the site shall in the meantime be allowed to remain as they are. My lords, this is what culminated into an inquiry under 37(2) and the order of the deputy collector, which is at page 179 of my lord's record,
Yes.
which is dated 19th May 1987.
Yes.
And if my lords would please permit me to read from page 185, the hukam.
Yes.
વેરાવલ તાલુકાના પ્રભાસપાટણ ગામના સર્વે નંબર સોએનસો 1851, 1852 તથા 1853 ની માલિકી સરકારી હોવાનું સાબિત માનવામાં આવે છે. અરજદારનો દાવો માન્ય રાખવામાં આવતો નથી. હકપત્રક સોએનસો 1852 શ્રી સોમનાથ ટ્રસ્ટને 999 વર્ષના પટથી આપ્યો છે તથા શ્રી સોમનાથ ટ્રસ્ટનો હક રહે છે. માલિકી સરકારશ્રીની. My lords, this came to be carried by the petitioner before the collector at page 187, which culminated into the order that was read by Mr. Thakur dated 20/11/1989. So I may not read it again. But the operative portion at 194, where it is clearly stated, सार्वजनिक हेतुथी मेळा माटे उपयोग करवामां आवे. A copy thereof was marked at page 195 to the Auliya-e-Din committee. And this has not been challenged by the Auliya-e-Din committee to the best of my instructions.
Yes. No, but the proceedings are pending.
They are pending, my lords. They are pending and this has not been challenged till date.
Yes.
My lords, that culminated into ultimately the petitioner approaching the learned civil court at Veraval as and by way of regular civil suit number 51 of 2015, which my lords would find at page 197. The prayers which I had read yesterday are at page 210, my lords,
Yes.
where of course declaratory relief is sought and customary rights are sought. 210-17A and B.
Why this suit was filed? What was the purpose of filing?
My lords, the purpose of filing of this suit was they were effectively seeking that, for all intents and purposes, seeking a declaration that this is Waqf property. This is the very suit that is not transferred, but returned on the request of the plaintiff
This was by the petition.
by the petitioner hearing, the plaintiff before the learned civil court. And the reliefs are that they seek customary rights. My lords, in this suit, the petitioners preferred, only for completeness of facts, page 287.
Yes.
In this suit, the petitioners preferred application exhibit 103, where the petitioners prayed that the suit be transferred, or, my lords, the last two lines, વિકલ્પે દાવાના તમામ પેપર સાથે સમક્ષ કોર્ટમાં હાલનો દાવો દાખલ કરવા, દાવો પરત કરવા હુકમ કરવા ફરમાવશો. My lords, this is 18/1/2020. If my lords were to turn the page on the very day at page 288, an order below exhibit 103 is passed, also on 18/1/2020, where operative portion at 291, the learned civil court returns the plaint to the plaintiff, my lords. My lords, below the return at 291 is an interesting endorsement because it will have some significance. If my lords were to see, seen, અસલ પ્લેન્ટ મળેલ છે તેમજ ખરી નકલ હુકમ મુજબ રજૂ કરી. And then one, what I understand, the signature of Mr. Rizwan, 7/2/2020. This becomes significant. I may pause here because before my lords in the present petition and before the other pending matter, the petitioner contends that I had absolutely no knowledge of this proceeding. That the petitioner contends in the present matter at paragraph 3.27. They remain dormant for a period of 4 years. Therefore, this endorsement becomes significant. And they say that our learned advocate came to be changed and therefore we had no knowledge of this exhibit 103 order. The same pleading is made slightly differently in the other matter. Pleadings whereof are also produced in my reply. My lords may only flag this. My lords, thereafter, there was no stay, and that led the respondent authorities to issue a notice dated 7/10/2023, which is at page 320. With my lord's permission, if I may. 7/10/2023, 320, my lords. તમોને નોટિસ આપી જાણ કરવામાં આવે છે કે તમોને વેરાવલ સોએન્સોની સરકારી જમીનમાં અનધિકૃત દબાણ કરેલ છે. આ અનધિકૃત દબાણ બાબતે તમોને આ સાથે સોએન્સો જમીનમાં કરેલ અનધિકૃત દબાણ તારીખ 8/10/2023 ના રોજ સવારે 8 કલાકે ખાલી કરવાનો કરી લેશો જી. My lords, this was not done, and therefore, admittedly, there is pleading that on 8/10/2023, steps were taken to remove this, which led the petitioner to approach our honorable court at page 321, the next page,
Yes.
the order that we read yesterday, my lords. I may not trouble my lords with the reading, but this petition came to be dismissed.
That is against contempt order.
On an exactly identical cause of action, not challenged by the petitioner before the honorable apex court. And the observations make it abundantly clear that there was no stay order as on date when the demolition was carried out. Only for reference, my lords, I am relying on the observation at page 336, paragraph 20, which says that thereafter there is no order of injunction which was operational on 9/10/2023 when the respondent took action impugned herein. And the observation at page 343, my lords, para 24, where there is a clear finding that there is no stay. My lords, after the suit is in the meantime returned by the trial court on 18/1/2020, it becomes Waqf plaint 5, it becomes the Waqf plaint before the learned Waqf board, Waqf tribunal, which is, and I have produced the plaint at page 513 of the record. I would pray my lords have the prayers therein at page 522. My lords, my instructions is filed on 11/2/2020, which is also the date reflected at page 523. 522 are the prayers. Para 17, my lords. A. Prabhas Patanna Chalta number so and so, revenue number, survey number 1853, acre so and so, Gutha so and so, Mangroli Shahwadu Kabristan, જે દાવા અરજી પારા 8 માં દર્શાવેલ હદ દિશાવાળી કબ્રસ્તાનની જમીન તથા ચાલતા સોએનસો ગુઠા દાવા અરજી પારા 9 માં દર્શાવેલ હદ દિશાવાળી સોએનસોની જમીન વેરાવલ તાલુકાના પ્રભાસ પાટણ ગામના મુસ્લિમ કોમની માલિકી વક્ફ માલિકી છે તેવું વિજ્ઞાપન આપવા અરજ છે. This is identical to the prayer before the learned Veraval court. B. વાદગ્રસ્ત કબ્રસ્તાન અને તેની જમીનમાં અમારી કોમની મૈયતને દફન કરવાનો અમોને કસ્ટમરી રાઇટ છે તેમ ઠરાવી આપવા અરજી છે. In my respectful submission, no prayers in the interim nature or any other nature are granted, and this suit before the learned Waqf tribunal remains pending.
Yes.
While all this is happening, the petitioner approaches our Honorable High Court on 12/9/2024 at page 479 of my reply.
Which number?
My lords, 479 by way of special civil application 13449 of 2024. If I may pray, my lords, have 486, the array of parties in this petition, which is pending and now listed on 8th October. My lords, the fifth petitioner at page 487 is the present petitioner. And I pray my lords have the prayers made in this petition. I'm sorry, before the prayers, para 19 may please be seen. Page 504, para 16.
So what is this order about? In this petition, what was the challenge?
My lords, that is what I am coming to. Okay, I'll directly come to the prayer first, my lords. May I pray, my lords, have 505.
Yes.
My lords, 20A. This honorable court may be pleased to quash and set aside the impugned order dated 18/1/2020.
What is this order?
The order by invitation. Return my plaint so I can go to the Waqf tribunal. Exhibit 103, which I showed to my lords, which is at page 287. With the operative order at 291.
So, no, but why this was then subject matter of challenge in this petition?
My lords, that according to the petitioner, so what happened was the petitioner failed in the MCA for contempt, where the petitioner contended that the order dated 19/1/2016, whereby some interim protection was granted to me against demolition, is operational. A division bench of our honorable court held on 9th August 2024 that is not the case, and no contempt can be found on the part of the respondents' authorities. Therefore, then realizing, and therefore I said, to overcome two observations of the Honorable Division Bench. The first observation being at page 336, I may read. Thereafter, there is no order of injunction which was operational on 9/10/2023 when the respondent took action impugned herein. And my lords, the second observation at page 343, para 26. This court is of the view, I'm sorry, my lords, page 336, para 20. And page 343, para 26, my lords. If I may read, in view of the aforesaid discussion, this court is of the view that once the order dated 18/1/2020 is passed below Exhibit 101 filed by the applicant, and the civil court below Exhibit 101 exercise power under Order 7, Rule 10(10)(a), order dated 19/1/2016 of the civil court will become non-existent and lose its efficacy, and thereafter it is not open for even the civil judge to extend it or pass an order to keep it operational. In the facts of the case, it is an admitted position that there is no similar order passed by the learned Waqf Tribunal. My lords, therefore, realizing that the division bench of our Honorable Court has come to this conclusion, the petitioners approach this Honorable Court on 12/9 by way of SCA 13449 of 24, where at 505 I was showing my lords the principal prayer. And my lords may please appreciate 18/1/2020 was a consent, it was an order by invitation. The petitioner made the request, but the interim prayer at 506, I'm sorry. Prayer B, my lords. Pending admission, hearing until final decision.
Now, which is the page number?
My lords, 506.
Yes.
My lords, the interim prayer. Pending admission, hearing until the final disposal of the present petition. This Honorable Court may be pleased to direct the respondents to maintain status quo on the suit property of Waqf Suit 45 of 2020. No Exhibit 5 application made before the learned Waqf Tribunal. Petition filed before our Honorable Court. And I may make a submission here. This interim prayer is akin to the interim prayer being sought for now, except the intervening event of 28th, which is the demolition. Our Honorable Court has not even issued notice in SCA 13449 of 2024. It was twice listed. On the second of those two occasions, the petitioner filed a sick note. It is now listed on 8/11/10, my lords.
Yes.
My lords, since my lords are now therefore on my reply, I pray my lords have page 510. This is, my lords, revenue entry number 1537. My reply page 510, my lords.
Page number?
My lords, 510. Am I with my lords? This is revenue entry 1537. If I may be permitted to read. Tarik 28/12/56, Shri Sarkar survey number 18495051, then 52 is stricken off. 1907, Nava तथा so and so 1743 थी फैजल भरी आवता And then this entry is certified on the right, my lords, on 25th of March 1958. So these lands were government lands, is what this entry reflects.
25th of March?
My lords, 1958. I've also put it in my affidavit, my lords.
Yes.
If my lords were to,
53 and 52 are not there in this.
we would come to that, Mr. Thakur. My lords may turn the page to 511 to solve Mr. Thakur's predicament. My lords, this is entry number 1538. तारीख 28/12/56, श्री सोमनाथ ट्रस्ट, सर्वे नंबर 1852, नवो तथा 146 एकड़ 34 गुठा तेने खाते मापणी थई नक्की थया एंट्री पड़ी, and this entry is also certified on 25th March 1958, my lords. Now, my lords, there is a significant acreage that may be noted by my lords. If my lord sees this entry at page 511, 146 acre, 34 gutha. While having 511 in hand, I pray my lords have 509, the government of Saurashtra notification. 2 pages prior, my lords. Item 4 that I had read to your ladyship, the acreage next to it, 146 acre, 34 gutha. So this is that very parcel, my lords, which is the waterfront land. My lords, a culmination of all these events, the pendency of the proceedings before the learned Waqf Tribunal without any relief, the pendency of SCA 13449 of 24 before our Honorable High Court without any relief, and the rejection of the contempt petition by our Honorable Court on 9th of August, all has led to the actions which are taken in the month of September, where there is no relief available to the petitioners. Although some documents are shown by the petitioner, I may pray that my lords have the Rojkam that was carried out on the date when the petitioners consentingly agreed to demolition. Page 461. My lords, there are in all about 9 or 10 Rojkams, all of which are produced on record. The date at page 461 is 27/9/2024. My lords, the names of the individuals 1, 2, and 3. ये बताओ छो. ये petitioner number का है. My lords, 1 is Gohel Shakil Hussain Bhai, 2 is Salim Moti Bhai Dal, and 3 is Ahmad Rahman. My lords, on the left side, my lords would see signatures of these gentlemen. And if my lords were to turn the page to 460 to the operative portion, from the end of the third line, આ દરગાહનો બાંધકામ દૂર કરવા માટે જમીન મહેસૂલ અધિનિયમ કલમ 202 તલે દરગાહ પર આવેલ બિનઅધિકૃત બાંધકામ તત્કાલિક અસરથી દૂર કરવા માટે 5/9/24 ના રોજ નોટિસ લગાવવામાં આવેલ, જેથી આ બિનઅધિકૃત બાંધકામ તત્કાલિક અસરથી દૂર કરવા અમો રૂબરૂ જાણ કરેલ છે. ઉપરોક્ત હકીકત અમારા પંચો રૂબરૂ મિલકતના સ્થળે લખાવવામાં આવેલ છે, જેમાં ખાતરી બદલ અમો પંચો અમારા પૂરા હોશો હવાસમાં કેજે વિના દબાણ કોઈ પણ જાતના શેર શરમ વગર વાંચી so સમજી વિચારી નીચે અમારી સહીઓ આપીએ છીએ. And these are the authorized signatories. Now, what becomes significant in one of these Panch Rojkams is page 473. The third signatory, Isa Nur Muhammad, who I am instructed is one of the committee members of the Awliya Din committee also.
Yes.
Therefore, the actions which culminated into the issuance of notice of 5th September, which was suppressed in the petition, was informed to the respondents on 27th September.